statutory interpretation intention,
Go beyond.
not based on original intention, not based on purposive teleological
So
interpretation.
you're really asking us to read into the statute the expression spouses for really man and woman.
So
And
does the
therefore,
underlying thrust of SMA exclude your lordship's reading or insertion or understanding of that construct? Is the
because your principal premise is that when the legislation was enacted in 1954,
yes,
the object of the legislation was to provide a form of matrimony for people who are not falling back on their personal law of marriage,
absolutely,
right? And not,
special categories.
you are giving a parliament was intending to provide an avenue to people beyond
Beyond.
your religious the religious governance of marriage, so to speak.
There was also an aspect of endogamy.
Yeah.
Yes. There was
Yes,
an aspect of endogamy
yes,
which
yes.
we cannot ignore.
Yes.
So it was an all-enfolding kind of a legislation.
And it cut across so many spectrum because it was intended to
And
be a very
therefore,
special category.
after 1954, in the last 46 and 69 years, our law has really evolved to recognize the fact when you decriminalize homosexuality, you also realize, well, these are not just one-off relationships. This also comprehends the stable relationship.
Because you go back and
Therefore,
say,
by decriminalizing homosexuality, we have not just recognized fleeting relationships between consenting adults of the same gender, right? We have also recognized implicitly, therefore, the fact that people who are of the same sex would be in stable relationships. Now, the object of the law in 1954 was to bring in its fold people who would be governed by a matrimonial relationship apart from their personal law. And surely that law is capable of being broadly read according to you, so as to take into account more stable relationships.
let me put it
of
bluntly.
the same sex as well.
Let me put it bluntly. When you enacted the law, you did not, in the debate in parliament, in the writing of the draftsman, when I get up and speak on it, may not have got homosexuals in mind. You may not have considered them.
Way of
That
looking
makes
at
no
it.
difference.
You may
Another
not.
way which you are perhaps propounding is this provided a framework, but that framework is of the concept of marriage. The
Exactly.
concept of marriage transcends
As it
contemporary understanding to
It's an evolving,
comprehend-
dynamic concept.
to
Absolutely.
comprehend an evolving idea of
Dynamic,
marriage.
very dynamic concept.
So used in a constitutional sense, it only provides a framework,
Framework.
and that framework is broad enough to assimilate later
Well,
developments.
I
So it
don't want to
transcends the existing.
I don't want to sound well. That is really well put with respect. The provision of a framework which departed from the existing framework already, because it took care of personal laws. Now, in that framework, are you cast in stone, or are you in an evolving dynamic picture? And can the underlying thrust and your lordship's institutional capacity sustain it? This is the summary of the whole Ghaidan principle applied to SMA.
And from the perspective of institutional capacity, we have to ask ourselves whether we would be doing something which would be fundamentally contrary to the scheme of the statute.
You also have to make a new
or
statutory
with
scheme.
Yeah, exactly. Would the
New
court be
statutory
rewriting the entirety of the statute? Would the court really be making policy choices which is for the legislature to make?
Lordship.
So long as we don't straddle that line which divides policy from the judicial process, you're still within the fold of it.
I'm very grateful, which is why they have put this second test. The
But
first test
equally,
was
I
enough.
think the impact of
Put a
Ghaidan
line.
is to liberate the court
Yes.
from the very, very traditional approach
Yes.
of looking at everything as a matter of statutory interpretation. Therefore, purposive interpretation also falls back on interpretation of that language, that statute.
That is important, Wallace. That teleological and purposive also, which is supposed to be an
I'll
advance,
play again-
falls back.
I'll play a little bit of a spoiler. Ghaidan provided the framework for the introduction of a law in 2004, which assimilated all these developments, which led to the blessing of statutory recognition of these kind of partnerships. And then it took another 10 years for these to be recognized as marriages. So that too is an aspect which we will have to keep somewhere in mind.
Absolutely, but your lordship, that's the difference. It's a holistic thing your lordship keeps in mind. Ultimately, the feel of the case is only a lordship will. That is, nobody can be identical. Nobody is saying
Because
it.
I'm sure if you go to Ghaidan and if you follow it up, there could be other cases which have followed
Now,
that.
so I've now time. Given
And
my
Dr.
time,
Sigsbee,
I've
we
done
have,
this.
Dr. Sigsbee, I think, I mean, looking at India constitutionally and socially as well,
Yes.
we have already reached the intermediate stage, right? The intermediate stage postulates that by decriminalizing homosexuality, your your very act of decriminalizing homosexuality does contemplate that therefore people who belong to the same sex would be in stable marriage-like relationships.
Marriage like is the operative word.
Right, marriage-like
Live
relationships.
together.
Because the moment we have said that it's no longer an offense under Section 377, therefore we necessarily contemplate that you could have a stable marriage-like relationship between two persons who do not treat these as chance encounters, but as something more than that, not just a physical relationship, but something more of a stable emotional relationship, right?
Societal.
Which now is an incident of our constitutional interpretation. Once we have made that, we have crossed that bridge, then the next question is as to whether our statute can therefore recognize not just marriage-like relationships, but relationships in the relationship
On the
of
contrary,
marriage.
Malaz, I started by saying it's a logical move in the same direction. It is, in fact, little done, vast undone. Your Lordship is now getting to cover that territory because to merely decriminalize is one category. Otherwise, it does, in an actual daily sense,
Of
remain
course,
a
it
shell.
requires us to,
Hollow
of course, it
shell.
requires us to redefine perhaps the evolving notion of marriage, because is the existence of two spouses who belong to a binary gender necessary, or the requirement for a relationship of marriage? Or has our law now progressed sufficiently to contemplate that the existence of binary genders may be, but is not necessary for your definition of marriage?
And Malaz, to that comes in the intersection of the Article 14. You in your counter and everywhere else are underlining immeasurably the vital importance of marriage, to which I bow down. But that vital importance of marriage is restricted to one category.
Expanding that definition, are we then trenching upon that area which Gaidan excludes to the judges?
That is, Malaz, in case your Lordship has got to stitch a whole cloth, which only a statute can do. That ultimately will be your Lordship's call. I don't think at all, which now, Lordship will just note on the side, para 44 is some other cases similar to Gaidan. I'll not read them. I don't have time to read them. Para 44 of my submissions. I'll now come to that 3 or 4 queries arising under the SMA, and then come to the notice of objections regime.
But in a way, Dr. Singhvi, I think what happened in the UK is really, in that sense, not in that. I was just talking to Justice Kaul, is not really in that sense in all fours with what happened in India.
Not at all.
The HRA in the UK was intended to enforce treaty obligations under the ECHR.
Yes.
Right? For us, we've always had the overarching principles of the Constitution, which lie above.
That's the irony. We are a for sure, Malaz, with respect. I'm saying on interpretation. This case is cited and the article is cited only for an approach to interpretation.
And, we are not here using the Constitution or utilizing the text of the Constitution to either read down a statute or to strike down a statute. That's one element of the impact of the Constitution. The other thing which we are doing now here is expanding the meaning of a statute in the context of constitutional guarantees. And in that, you are saying be liberated from the bare text of the Constitution or the notion of parliament.
First part of what I argued yesterday was dignity, non-discrimination.
See, in the backdrop of constitutional interpretation, we have never used the originalist doctrine, right? India, unlike what Justice Kalia said, we have never regarded ourselves as bound by an originalist interpretation.
Kalia is an extreme example.
In which case, Dr. Singhvi, if we have never been bound by an originalist interpretation of the Constitution, should we be bound by an originalist interpretation of the statute? Which is in that sense subordinate to a constitution.
And he, their Lordship knows that a court of one. He said, if I'm the only one, I'll always stick to this original intent. Court of one. So, your basic, all that I'm saying is, one, because I've done the constitutional aspect, yes, unless your Lordship anchors it in the values of 14, 15, 16, 19, 21. That's the first
part. But to put it really bluntly, is the relationship between a man and a woman so fundamental to our law and therefore the Special Marriage Act that for us to comprehend that it will also include a relationship between a same-sex couple would be completely redoing the tapestry of the legislation.
So this
if we say yes, then obviously we cannot.
The underlying agnostic thrust is the underlying agnostic thrust of SMA. antithetical to your lordships recognizing what Article 14 normally will always include, namely same-sex persons enjoying the same importance and benefits of marriage as different sex persons. That's the long and short of it. As an aid to interpretation, I've only cited one case which says, and the only interpreted statutory out of the Constitution. Does the underlying thrust, alternatively, an interpretation of SMA, well, prohibit or preclude your lordship from doing so? Or is your lordship's institutional capacity so compromised by a particular case that your lordships cannot do it? That's the fourfold way, connecting yesterday and today.
And really, your argument is that, the institution of marriage in itself
Yes.
is so very important
Well,
that
to
to deny it to same-sex couples would be really contrary to fundamental constitutional values.
sorry to interrupt, my Lord the Chief Justice, because my note yesterday, I said it, para 15 lists 7 important indicia of marriage, and the appendix
Correct.
lists more. Their counter says so. I rely on it heavily. The question is only exclusion. You have it for that side of the table, you don't have it decided. Para 15 of my submissions. My Lord were kind enough to note it down also by hand. Now, without that, if I was to straight away jump into an interpretation exercise of Ghaidan, it would be wrong on my part. I'm completing my argument.
Dr.
I'm going
we're just reminding you it's 12:17.
No,
Now, Ghaidan is over. This article
No,
is
therefore,
done. We've got the trust. Now, what's the next one?
the next one. Now, let's very quickly. One, I'll be very pointed. Justice Bhatt put a question to me about Justice Lahoti's order. That's 2005, 3 SCC 313. Don't bother, just I'm giving a copy to your lordships. Just note, it was a different case. Justice Bhatt said so yesterday. It's a different case. Context was different. It was really about, again, a tenancy law invoked by.
This was in the absence of the domestic.
Deserted wife to claim tenancy, etc. But leave that, Para 1, your lordship will note, the words are evocative. I'm just moving on. Just para 1 of that,
Dr. Singhvi, what exactly? 2005, 3 SCC?
2005, 3 SPC, 313. Just note para 1. I'll read it fast, lordship need not open it. I'll just read it for lordship. Only para 1. The law, it connects with what I'm saying. And therefore, your lordship put this question to me yesterday. The law does not remain static. It does not operate in a vacuum. As social norms and values change, laws too have to be reinterpreted and recast. Law is really a dynamic instrument fashioned by society for the purpose of achieving harmonious adjustment, human relations by elimination of social tension and conflict. I'll leave it at that, That's just a. The second thing, my Lord Justice Bhatt put to me. My Lord, remember that passage, so I've traced it out. That's only. Secondly, my Lords put to me. My Lords put to me.
The contractual relationship.
Yeah.
It's our Ghaidan moment in a different
right.
context. It's our Ghaidan.
This is a kind of a Ghaidan. I mean, it's a little. Your lordship is right. That's a tenancy case, but
You see, the interesting part is this predates the domestic violence in Act.
domestic. That's what your lordship put to me yesterday. That's the point. That's the point. So they static, dynamic, moving. That's the whole point. Second, my lord put a question which will have to await research. I can't give your lordship a different, but what is one of the examples I found? For example, in one narrow case of standard personal accident insurance, what my lord put to me, is there a statutory regulation? There is by IRDAI, not in the mass of others, but in that, which use the phrase legally wedded spouse. Now, I will make that chart and give it later. I'm not considering, suppose your lordship were to hold that SMA includes this form of marriage. They would be legally wedded spouse in the sense that your lordship, after your lordship's date of may fall within that again. But that is one of the few regulations which has the phrase. The large bulk doesn't. Where that phrase is there, it will depend, on your lordship's judgment. But your lordship, according to me, even where it finds same-sex persons in marriage valid, would be covered under that. I've given you a specific quote of a particular IRDA regulation. The third thing, is how to apply this gender. The third thing is, just note in bullets, the answer on this. This is important. Your lordship has one situation about 2B and the first Act. Answer: both parts of both schedules will have to apply to non-heterosexual couples. The prohibited category yesterday your lordship discussed.
Yes.
Both parts of both schedules will have to apply to non-heterosexual. It does no violence to your lordship's sense of that your lordship is making a statutory scheme. Nothing. The statutory scheme exists. My lord is not saying whether he and I are prohibited category. Whether he and I are prohibited. Lordship is not defining. Your lordship is saying it will apply on both parts. That's answer number one. No
Can you say that
violence to the
again?
underlying
Can
class.
you say that again? Can you say that? Repeat that.
Yes, the two schedules in question for the issue of prohibited degrees of relationship will apply, both of them simultaneously, to all non-heterosexual couples.
That's what Mr. Rohtgi said.
That's right. So we are now ironing out your lordship.
It will collapse into one.
Yeah. Suppose your lordship has to make out a prohibited relationship. That would be legislation. Suppose your lordship, I am asking to do something which creates something. Nothing. Your lordship is reading in something and making it harmonious. Second, 4C, age